Mic check, check.
Check, check, check. Audio check. Yes. One, two, audio check, sound check. Check, 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 check. Marka bang.
Check, check, check.
Yes, sir. Yes.
I'll read out the conclusion which we have arrived at. In view of the above discussion, we conclude that A, after 1 April 2021, the Income Tax Act has to be read along with the substituted provisions. B, TOLA will continue to apply to the Income Tax Act after 1 April 2021 if any action or proceeding specified under the substituted provisions of the Income Tax Act falls for completion between 20 March 2020 and 31 March 2021. C. Section 3(1) of TOLA overrides Section 149 of the Income Tax Act only to the extent of relaxing the time limit for issuance of a reassessment notice under Section 148. D. TOLA will extend the time limit for the grant of sanction by the authority specified under Section 151. The test to determine whether TOLA will apply to Section 151 of the new regime is this. If the time limit of 3 years from the end of an assessment year falls between 20 March 2020 and 31 March 2021, then the specified authority under Section 151(1) has extended time till 30 June 2021 to grant approval. E. In the case of Section 151 of the old regime, the test is if the time limit of 4 years from the end of an assessment year falls between 20 March 2020 and 31 March 2021, then the specified authority under Section 151(2) has extended time until 31 March 2021 to grant approval. F. The directions in Ashish Agarwal will extend to all the 90,000 reassessment notices issued under the old regime during the period 1 April 2021 and 30 June 2021. G. The time during which the show cause notices were deemed to be stayed is from the date of the issuance of the deemed notice between 1 April 2021 and 30 June 2021 till the supply of relevant information and material by the assessing officers to the assessees in terms of the directions issued by this court in Ashish Agarwal, and the period of 2 weeks allowed to the assessees to respond to the show cause notices. And H. The assessing officers were required to issue the reassessment notice under Section 148 of the new regime within the time limit surviving under the Income Tax Act read with TOLA. All notices issued beyond the surviving period are time barred and liable to be set aside. The judgments of the High Courts rendered in Union of India versus Rajiv Bansal, Allahabad High Court, Kinara Industries Private Limited versus ITO Surat, High Court of Gujarat, JM Financial and Investment Consultancy Services Private Limited versus ACIT, High Court of Judicature at Bombay, Siemens Financial Services Private Limited versus DCIT, High Court of Judicature at Bombay, Geeta Agarwal versus ITO, High Court of Judicature at Rajasthan, Ambika Iron and Steel Private Limited versus PCIT, High Court of Orissa, Twilight Infrastructure Private Limited versus ITO, High Court of Delhi, Ganesh Das Khanna versus ITO, High Court of Delhi, and other judgments of the High Courts which are relied on these judgments, are set aside to the extent of the observations made in these judgments. The appeals filed by the revenue are accordingly allowed. The appeals filed by the assessees will be governed by the reasons discussed in this judgment. The transfer petitions are accordingly disposed of.
Lordship, this will go back to the High Court for in the light of these judgments? Because there are other issues or contentious over there.
Yes.
This will go back to the
Yes, any other issues which remain will be dealt with.
Maybe just to clarify on that issue, will go back because there were many issues raised before the High Court. High Court had decided only on these issues.
May please, my lords.
Just take down a separate order. If independent of the sorry, don't say that.
Can it be suggested? Can they file an independent writ petition so that we can?
No, Lordship, because there was all these petitions were there, Lordship.
My lords,
High Court has been categorically.
Your lordship may grant them the liberty to file issues. We have notified.
Will dispose of the objections in terms of the law which has been laid down by this court. Full stop. Thereafter, the assessees who are aggrieved will be at liberty to pursue all their rights and remedies in accordance with law, save and except with regard to matters which are concluded by the present judgment of this
All
court.
rights and contentions are black.
Yes, of course, yes. Sir.
All rights and contentions are left.
No, we'll accept what is decided by us.
All right.
Thank you.
Excuse me.
May I please, my lords, can I just,
Chalo now. Yes.
may I please, my lords, can I just,
On the PRISM reform, it was a very beautifully researched petition. We must compliment the lawyers who argued it in both the sides for giving us so much of food for thought in laying down this judgment. The petitioners challenged various provisions in the state prison manuals on the grounds of being violative of Articles 14, 15, 17, 21, and 23 of the Constitution of India. It was highlighted that caste-based discrimination continues to persist in the prisons in the country with respect to 1. The division of manual labor, 2. Segregation of barracks, and 3. Provisions which discriminate against prisoners belonging to denotified tribes and habitual offenders. I'll just briefly run through how we have divided the judgment. The first segment of the judgment deals with constitutional interpretation. Next, in that we have said the criminal laws of the colonial era continue to impact the post-colonial world. Criminal laws in modern times, thus, as the strongest expression of the state's power, must ensure that they do not deny equality before the law and the equal protection of laws. Our criminal laws must not endorse colonial or pre-colonial philosophies. In the post-constitutional society, the law must take affirmative steps to achieve equal protection of law to all its citizens. Any discussion on the Constitution must therefore take a conscious view of the lived realities of citizens. It requires evaluating how constitutional provisions translate into meaningful outcomes in their lives. We must discuss this aspect of the Indian Constitution before further examining the impugned provisions. Next segment, we have dealt with the Constitution of emancipation, equality, and dignity. And we have said the fight against caste-based discrimination is not a battle that can be won overnight. It requires sustained effort, dedication, and the willingness to confront and challenge societal norms that perpetuate inequality. When faced with practices of caste-based discrimination, this court must take an active stand. In entertaining the current petition, this court is making its contribution to the ongoing struggle to dismantle caste-based discrimination. Then we've dealt with the contours of Article 14 and the concept of manifest arbitrariness. Next, we dealt with non-discrimination under Article 15 and why discrimination. We've dealt with various facets of that. We have said, based on the analysis of the judgment, certain anti-discrimination principles emerge under Article 15(1). First, discrimination can be either direct or indirect, or both. Second, facially neutral laws may have an adverse impact on certain social groups that are marginalized. Third, stereotypes can further discrimination against a marginalized social group. Fourth, the state is in the positive obligation to prevent discrimination against a marginalized social group. Fifth, discriminatory laws based on stereotypes and causing harm or disadvantage against a social group, directly or indirectly, are not permissible under the constitutional scheme. Sixth, courts are required to examine the claims of indirect discrimination and systemic discrimination. And seventh, the test to examine indirect discrimination and systemic discrimination has been laid down in judgments of this court. Then we deal with the fundamental right under Article 17, where we say that Article 17 puts an end to the socially discriminatory practice of untouchability. Throughout our history, the oppressive nature of the caste structure has denied to those disadvantaged castes the fundamentals of human dignity, human self-respect, and even some of the attributes of the human personality. Article 17 enunciates that everyone is born equal. There cannot be any stigma attached to the existence, touch, or presence of any person. By way of Article 17, our Constitution strengthens the equality of status of every individual and citizen. The laws enacted under Article 17 aim to provide dignity to the affected individuals. Then we have dealt with Article 21 and the of life and dignity. We have said not providing dignity to prisoners is a relic of the colonizers and pre-colonial mechanisms where oppressive systems were designed to dehumanize and degrade those under the control of the state. This court, focusing on the changed legal framework brought out by the Constitution, has recognized that even prisoners are entitled to the right to dignity. They are to be treated humanely and without cruelty. Police officers and prison officials cannot take any disproportionate measures against prisoners. The prison system must be considerate of the physical and mental health of prisoners. For instance, if a prisoner suffers from a disability, adequate steps have to be taken to ensure their dignity and to offer support. Then we dealt with Article 23, the prohibition of forced labor and human trafficking. The broad scope of Article 23 can be invoked to challenge practices where no wages are paid, non-payment of minimum wages takes place, social security measures for workers are not adopted, rehabilitation for bonded labor does not happen, and in similar unfair practices. The state shall be held accountable even in cases where the violation of fundamental rights such as Article 23 is done by private entities. Article 23 can also be applied to situations inside prisoners if the prisoners are subject to degrading labor or other similar oppressive practices. Then we have said that we must now reflect on the patterns of discrimination against the scheduled castes, scheduled tribes, and denotified tribes. We have then, in the next segment, dealt with the history of discrimination in both pre-independence and post-independence India. The history of India has witnessed centuries of discrimination towards the oppressed castes. Violence, discrimination, oppression, hatred, contempt, and humiliation towards these communities were the norm. The caste system entrenched these social injustices deeply within society, creating an environment where the principles of natural justice were blatantly disregarded. In this hierarchical system, neutrality was virtually non-existent, and there was an inherent and pervasive bias against those belonging to the oppressed castes. This bias manifested in numerous ways, including exclusion from social, economic, and political opportunities. The colonial history indicates that the British reproduced the systems of social hierarchy in their legal framework. These caste-based stereotypes were given the form of the Criminal Tribes Act of 1871. The legislation of 1871 empowered the government to declare any community as a criminal tribe. The provisions of the Criminal Tribes Act were based on a stereotype which considered several marginalized communities as born criminals. The Criminal Tribes Act was repealed in 1952. The criminal tribes were then denotified, as a result of which they were known as denotified tribes. It must be noted that under the Criminal Tribes Act, several marginalized castes were also declared as criminal tribes. It is for this reason that Article 341 of the Constitution employs the words castes and tribes while defining the scheduled castes. Discrimination against the scheduled castes, scheduled tribes, and denotified tribes has continued in a systemic manner. Remedying systemic discrimination requires concrete, multifaceted efforts by all institutions. In discharge of their role, courts have to ensure that while there should be proper implementation of protective legislation, as the Atrocities Act, there should not be unfair targeting of members from marginalized castes under various colonial era or modern laws. With this nuanced approach, we shall now examine the prison manuals. Then we have dealt with the prison manuals at length, and we have said that caste can be an intelligible principle of classification as it has been used to create protective policies for the marginalized castes. Furthermore, the Constitution provides for the enumeration of certain castes and tribes as scheduled castes and scheduled tribes in order to facilitate protective discrimination and overall promote equitable distribution of resources. However, as evident from Article 15.1, caste cannot be a ground to discriminate against members of marginalized castes. Any use of caste as a basis for classification must withstand judicial scrutiny to ensure that it does not perpetuate discrimination against the oppressed castes. In the context of prisons, a valid classification must be a functional classification. However, there is no nexus between classifying prisoners based on caste and securing the objectives of security or reform. Inmates are entitled to fair treatment that promotes rehabilitation, and classification of any kind must be geared towards the same. Segregating prisoners on the basis of caste would reinforce caste differences or animosity that ought to be prevented at the first place. segregation would not lead to rehabilitation. The differentia between inmates that distinguishes on the basis of habit, custom, superior mode of living, and natural tendency to escape is unconstitutionally vague and indeterminate. These terms and phrases do not serve as an intelligible differentia which can be used to demarcate one class of prisoners from the other. The objective of classification for labor, for treatment, and for conferment of entitlements, such as remissions, has to be maximization of the reformatory potential of prisons. Classification based on caste reduces the individual prisoner to a group identity and does not leave room for an objective assessment of their correctional needs. Their reformation is stultified by the burdens of their group identity and thereby their presumed ability to discharge stereotypical occupational tasks. The classification on obsolete understanding of caste based on pre-constitutional legislation and practice lacks a rational nexus with the correctional objectives of classification in prisons. Thus, rules which discriminate against individual prisoners on the basis of their caste, specifically or indirectly by referring to proxies of caste identity, violate Article 14 on account of invalid classifications and subversions of substantive equality. Then we dealt with Article 15, and we have said by assigning cleaning and sweeping work to the marginalized castes while allowing the high caste to do cooking, the manuals directly discriminate. This is an instance of direct discrimination under Article 15. The manual and rules also suffer from indirect discrimination by using broad terms which act to the disadvantage of the marginalized castes. Phrases such as menial jobs to be performed by castes accustomed to perform such duties may appear to be facially neutral, but refer to marginalized communities, given the history of systemic discrimination against them. Such indirect uses of phrases which target the so-called lower castes cannot be permitted in our constitutional framework. The phrases, though neutral on their face, carry an embedded bias which disadvantage marginalized communities by reinforcing historical patterns of labor based on caste. Even if caste is not explicitly mentioned, phrases like menial and accustomed indirectly uphold traditional caste roles. These provisions disproportionately harm marginalized castes, perpetuate caste-based labor divisions, and reinforce social hierarchies. The manuals and rules also reinforce stereotypes against denotified tribes. The tendency to treat members of denotified tribes as habitual to crime or having bad character reinforces a stereotype which excludes them from meaningful participation in social life. Members of the denotified tribes have faced the brunt of colonial caste-based undertones of discriminating against them, and the prison manuals are reaffirming the same discrimination. Discrimination against the denotified tribes is prohibited on the ground of caste in Article 15(1), as the colonial regime considered them as belonging to separate hereditary castes. Then we have dealt with whether this amounts to a practice of untouchability under Article 17. For instance, Rule 289G of the Uttar Pradesh Manual provides a convict sentenced to simple imprisonment shall not be called upon to perform duties of a degrading or menial character unless he belongs to a class or community accustomed to perform such duties. We have said the notion that an occupation is considered as degrading or menial is an aspect of the caste system and untouchability. The caste system has rigidly assigned certain tasks to specific communities. Similarly, the reference to scavenger class is a practice of the caste system and untouchability. No social group is born as a scavenger class. They are forced to undertake certain jobs that are considered menial and polluting based on the notions of birth-based purity and pollution. The provision that food shall be cooked by suitable caste reflects notions of untouchability, where certain castes are considered suitable for cooking or handling kitchen work, while others are not. Besides, the division of work on the basis of caste is a practice of untouchability prohibited under the Constitution. The impugned provisions deal with the habits of certain communities. The provisions that men of wandering tribes or criminal tribes have a strong natural tendency to escape or by habit accustomed to theft reflects a stereotype that has its basis in the colonial understanding of India's caste system. These stereotypes not only criminalize entire communities, but also reinforce caste-based prejudice. They resemble a form of untouchability as they assign certain negative traits to specific groups based on identity, perpetuating their marginalization and exclusion. By marking them as criminal by birth, the law institutionalized a prejudiced view of these tribes, treating them as inherently dishonest and prone to theft. And then we have reimagined and re-envisioned Article 21 with a section which says, the right to overcome caste prejudices under Article 21. We have said the impugned rules foster the antiquated notions of fitness of a particular community for a certain designated job. These rules reinforce occupational immobility of prisoners who belong to certain castes. For instance, rules assign sweeping work that stipulate that sweepers shall be chosen from the Mehtar or the Hari caste, also from the Chandal or other low castes, if by the custom of the district they perform similar work. They designate the enumerated castes for the work in issue. Such rules are indifferent to the potential of the individual prisoner to reform. Such a state of affairs is entirely opposed to substantive equality, as it contributes to institutional discrimination, depriving inmates of an opportunity to reform at part with others over whom the pall of caste does not hang. Then we have dealt with Article 23, and we have said that such provisions often lead to an unfair distribution of labor within the prison system, with persons from specific communities performing honorable tasks, while those from marginalized communities are forced into undesirable work. We put that in italics. The type of labor assignment based on their caste cannot be classified as voluntary. Forcing the members of oppressed castes to selectively perform menial jobs amounts to forced labor under Article 23. Dr. Ambedkar had articulated that the socio-economic situation of oppressed communities should not be used to exploit their labor. Article 23 strikes at this philosophy. The said article is not a caste-ignorant provision, but a caste-conscious provision. Then we've dealt with the Model Prison Manual 2016 of the Government of India, and we have said that the model suffers from several lacunae. The first issue to be noted with reference to the manual is its classification of habitual offenders. The manual defines habitual offender as a prisoner classified as such in accordance with the provisions of applicable law or rules. We have highlighted that the phrase habitual offender in several prison manuals refers to people from denotified or wandering tribes. Therefore, this definition cannot be left to be interpreted and applied in accordance with the provisions of applicable law rules. Otherwise, it will end up doing what it will end up doing is to classify and separate people from denotified tribes in prisons without any basis. Second, the manual does not explicitly prohibit physical caste-based segregation of prisoners, except in prisons for women. This is concerning, as the manual was prepared in 2016, when prison manuals in different states mandated caste-based division of prisoners. The manual of 2016, therefore, should have adopted a specific provision prohibiting the classification of prisoners on the basis of caste for all prisoners, as it does in the case of women prisoners. Third, the manual does not prohibit division of work on the basis of caste, except in cooking. As analyzed, various prison manuals in different states specify different work to people on the basis of caste. Fourth, the counsel for the petitioner have argued that the manual does not refer to the provisions of the Prohibition of Employment as Manual Scavengers and the Rehabilitation Act 2013, which prohibits manual scavenging. We clarified that the Act has a binding effect even on prisons. In relation to toilets, manual scavenging or hazardous cleaning of a sewer or septic tank inside a prison shall not be permitted anymore. Fifth, it has also been argued that caste-based privileges provided to certain prisoners are not forbidden, except in para 17.22. We clarify that no special treatment shall be given to any group of persons or individuals on the basis of caste in any scenario. In the next segment, we have dealt with the Model Prisons and Correctional Services Act of 2023, and we have said that the Model Act does not contain a reference to the prohibition of caste-based discrimination. Then we have said that the definition of habitual offender under section 2(12) is also problematic. And then in the next segment, we have dealt with the continued targeting of denotified tribes and said that the habitual offender legislations were enacted to replace the Criminal Tribes Act. However, in states such as Rajasthan, they were used to refer to members belonging to criminal tribes and denotified tribes. Applying that logic, several prison manuals or rules have also referred to habitual offenders to mean members of denotified tribes or wandering tribes. This cannot be accepted. A whole community ought not to have either been declared a criminal tribe in the past or a habitual offender in the present. It would not be wrong to say that the classification of habitual offender has been used to target members of denotified tribes. Next, we have referred to substantive equality, and where we have said, what does the future hold for India? Dr. Ambedkar had expressed this concern in his last address to the Constituent Assembly. The concern holds true even today. More than 75 years since independence, we have not been able to eradicate the evils of caste discrimination. We need an institutional approach where people from marginalized communities could share their pain and anguish about their future effectively. We need to reflect and do away with institutional practices which discriminate against citizens from marginalized communities or treat them without empathy. We need to identify systemic discrimination in all spaces by observing patterns of exclusion. After all, the bounds of caste are made of steel, sometimes invisible, but almost always inextricable, but not so strong that they cannot be broken with the power of the Constitution. This petition highlighted an instance of institutional systemic discrimination. We appreciate the assistance provided by the lawyers in dealing with the issue. In light of the discussion, we issue the following directions. 1. The impugned provisions are declared unconstitutional for being violative of Articles 14, 15, 17, 21, and 23 of the Constitution. All states and union territories are directed to revise their prison manuals and rules in accordance with this judgment within a period of 3 months. 2. The union government is directed to make necessary changes as highlighted in this judgment to address caste-based discrimination in the Model Prison Manual of 2016 and the Model Prisons and Correctional Services Act 2023 within a period of 3 months. 3. References to habitual offenders in the prison manuals or Model Prison Manual shall be in accordance with the definition provided in the habitual offender legislation enacted by the respective state legislatures, subject to any constitutional challenge against such legislation in the future. All of the references or definition of habitual offenders in the impugned prison manuals or rules are declared unconstitutional. In this case, there is no habitual offender legislation in the state, the union and the state governments are directed to make necessary changes in the manuals or rules in line with this judgment within a period of 3 months. 4. The caste column and any references to caste in under trial and or convict prisoners registers inside the prisons shall be deleted. 5. The police is directed to follow the guidelines issued in Arnesh Kumar and Amanutullah Khan to ensure that members of denotified tribes are not subjected to arbitrary arrest. 6. This court takes suo motu cognizance of the discrimination against inside prisons on any grounds such as caste, gender, disability, and shall list the case from now onwards as in-rate discrimination inside prisons in India. The registry is directed to list the case after a period of 3 months before an appropriate bench. 7. On the first date of hearing of the above suo motu petition, all states and the union government shall file a compliance report on this judgment. 8. The District Legal Services Authorities and the Board of Visitors formed in the Model Prison Manual 2016 shall jointly conduct regular inspections to identify whether caste-based discrimination or similar discriminatory practices as highlighted in this judgment are still taking place inside prisons. The District Legal Services Authorities and the Board of Visitors shall submit a joint report of their inspection to the State Legal Services Authorities, which shall compile a common report and forward it to the National Legal Services Authority, which shall in turn file a joint status report before this court in the above mentioned suo motu petition. 9. The Union Government is directed to circulate a copy of this judgment to the Chief Secretaries of all states and union territories within a period of 3 weeks from the date of delivery of this judgment. The petition is accordingly disposed of in the above terms. Pending applications, if any, shall stand disposed of. Thank you very much for your assistance. And Ma'am Sukanya Shanta, thank you very much for writing that very well-researched piece which got this whole proceeding started. But for your piece, nothing would have changed on the ground. And hopefully with this judgment, things will change on the ground.
Much obliged, Your Honor.
This just highlights the power of the law. When citizens, in bona fide petitions come to court, they write articles, they research on the ground realities, and then bring matters to court so that we can resolve them. Thank you for your assistance. Thank you, Ms. Vadekar. Please thank Dr. Muralidhar also, and thank you to Ms. Aishwarya Bhati on the other side, who argued also very objectively.
Lord, the Lordship's leave.
Yes,
Sorry.
Monday.
Mentioned, Lord, an extremely urgent matter
what is that?
which ought to be taken up today. And I'll tell Lordship why. Lord, I represent Isha Foundation, which is not run by a very respected person called Sadhguru. We see him on TV, we see his lectures. It is not an institution in Coimbatore, which has 5,000 people living there. We have schools, we have everything inside. So, originally, there are two ladies who are there, who have been living there 10 years. 15 years. First, the mother filed habeas corpus 10 years ago in the High Court that they have been taken away, etc. They appeared, they are 30 or 40 years of age. And they said, we are living there of our own accord, that habeas corpus is disposed of. After 8 years, the father files another habeas corpus. The father files, another habeas corpus on the same ground for the same daughters. They, again appear before the court 2 days ago on the first date and said, we are living here, they are educated, they are engineers. They are monks now, they are living there. They say we have renounced the world and we are living there. They made a statement in the High Court records. But High Court says that the father says, habeas corpus.
When was that second statement? That was again 2 years back? Or?
2 days back. No, 2 days back.
All right, 2 days back. Yes.
I filed it over.
All right.
2 days back. The women appear, they are now 39 and 35 years of age. They are engineers and something else. So they appear and they say, habeas corpus is over. The father says, I suspect that in this huge complex, there may be other people who are also kept like this. The court says this is a very serious statement and therefore I order a police investigation to go into their ashram. So 500 people of the police in my ashram since yesterday, examining every room, examining every person, and the High Court says, now you give me a status report. Habeas corpus is over, These are matters of which are contours of religious freedoms. People want to be a monk. Somebody will live, somebody will not live. But it's not a case of habeas corpus. These are contours of, this is happening. And all over, I respectfully submit, it's a one-page order, Need copies.
All religions.
Lord,
It's... Copy.
the Union of India,
So it's a paper book?
Yes, I have
Yes.
one.
I appear for the Union of India. Lord, this needs your lordship.
Just have a look at.
The High Court should have been very circumspect, my lord.
Mr. Shankar, if you can give us even your iPads
Yes.
on a returnable basis.
No. It can be on one-way basis also.
No.
We have provided to all our juniors on one-way basis. So
if the juniors get it, the Supreme Court has provided it to my colleagues also. This is the effort to make our whole system digitized. Give me a...
my lord may have this. Now just see this.
Let's see first the order of the High Court.
See the order.
What page?
Page 1 at page 2.
30th September.
Page 1 and page 2 passed 2 days ago.
This one.
Page 1 at page 2 below.
4 paragraphs order? Yes.
Yeah, correct. First day order. And both the ladies appeared because the lawyer told us that a petition is coming. We asked them to appear. Their ages are 42 and 39. We have examined both the detainees, the petitioner. Petitioner is a retired professor. Petitioner is a scientist and so his 2 daughters providing education up to engineering. Both of them joined an institution called Isha Foundation. Now the grievance of petitioner is foundation abusing certain persons, brainwashing, converting the monks, not even allowing the parents to meet the situation is also widely criticized. Petitioner in person will submit. Even recently a criminal case was registered against him. Allegations was the person he molested. Counsel would submit there are several other cases registered. If all below general, nothing. In view of the serious nature of allegations raised and the way the matter of details have spoken to us, we could form open some more deliberations required to understand the truth. Therefore, petitioner produce details. Petitioner will produce, that is the other side, all cases, etc. The prosecutor will collect details. Last page. In para 15, it is stated that on so-and-so in the evening, his elder daughter suddenly called the petitioner mobile, said his daughter is fasting so-and-so. With reference to the allegation, he'll conduct an inquiry, file a status report. And this is the second order after 8 years, below. The first order, below, was also there. Page 20, my lord, is the second order.
2016.
Tell us one thing.
Yes.
This, did the two monks, as you call them?
Yes. Now they are monks.
Yeah. Did they appear in court or were they statements?
Yes, physically.
They're available online today.
They are available online even now. I've told them to be available.
Did they appear in the court?
Yes, my lord.
First line.
And they appeared.
Before the division bench.
Yeah, that's the first line.
Now, wait, yes,
First line, my lord.
we seem to have.
The court has interacted with the detainees.
We have examined both the detainees.
Yes. And my lord, the mother,
They said in the court, has that been documented on the record or anything like that?
that my lord, they appeared.
Yeah, no, what they said in the court, because the judges don't record what they said in the court.
This is all there is to it.
Okay.
Your lordships can ask them. And the first order in the mother's petition 8 years ago, same thing happened, my lord, which is at page 21. So it's, my lord, there is somebody behind all this, that this is going on. We have a blemishless record. 5,000 people live in this ashram, my lord. Page 21. Kindly turn to page 20.
He said one aspect which we must put to you,
Yeah.
the court has recorded the petitioner in person would submit that even recently a criminal case in a POXO has been registered against a doctor who is working in the same institution.
My lord, he's a doctor, it has nothing to do with us. He's not on these premises. I mean, my lord, we have millions of people who come there. Your lordships are aware, Auroville, there's so many people who visit on a daily basis. You have Osho, my lord, in Pune. You can go daily basis, you can live there. So, how can this, my lord, you have a 500 people, my lord, in our ashram.
To do with your ashram?
Sorry, my lord.
The allegation against the said person was that he molested 12 girls studying in the Adivasi government school. What has this Adivasi government school to do with the
No,
Nothing to do.
no.
This fact,
Because that man kept saying, the court kept recording. It's all, your lordship find is all oral. There is not a vestige of documentation. Yes.
purpose why we are asking.
Yeah, correct.
Petitioner in person would submit that even recently a criminal case under POXO has been registered against a doctor who is working in the very same institution. Correct.
No, my lord, it's not correct. Your lordship sees page I. The answer is in page I.
Our response. The second sentence. Allegation against the said person was that he so-and-so in the Adivasi government school. So after this incident, he is working in your...
Lord, it has not occurred in our premises. We have said that at page I, ground S. Kindly see. It can't be, my lord, on oral assertions. The High Court starts an inquiry. You violate our, my lord, freedoms.
We take it that part in the last sentence of para 1,
Yeah.
that whatever criminal case against a doctor in the allegations,
That's all right, my lord.
that
We are not appealing for the doctor.
difficulty about, because that must go on.
Yes, yes, of course, my lord. How can anybody say with a POSCO case, we should say stop it? How can I say that? But I am only concerned, my lord, habeas corpus was over when these women appeared at age 42 and 35.
No,
They
habeas
are-
means bring the body.
They are there.
They were there.
Lots-
They were all
There are
35, 40
several
years.
other, where they say that the counsel for the petitioner submitted that there are several other criminal cases registered and allegations are pending.
There is nothing on record, my lord. I can't just answer like this on that day. I mean, if somebody has some registered somewhere out of 5,000, I can look at it. But we have a blemishless record, my lord. And where are the ladies?
Is referred to in the last sentence of para 1. Is he working in your institution?
No, my lord, answer is at page I.
Para SS.
Come back, my lord, to page I.
Page I.
Page I, ground S.
So you have taken instructions in this regard?
You know, it is working with us.
This doctor is not serving in your.
It is recorded, bro. Page S.
He is not employed. He is not.
Page I.
S, page I, ground S. Working with us, my lord, it never happened in our premises. And your lordship may make it clear that the POSCO case against the doctor will go on. We have nothing to do with it. We have produced these women. They appeared on day one. My lord, it happened earlier. This is history repeating itself at page 21. This is the mother's petition, 6-page order. They appeared, then he also appeared.
Now, are the Mr. Rogi, are the two women online right now?
Yes, they are online.
Yeah, we asked them to remain online.
Are they presently online, Mr. Agarwal?
We are, my lord. Yes, just.
Let me call somebody, please. Call them.
You need to open it or something.
It's something.
Maybe they're online. 499 people are online.
This is somebody else here.
No.
You're on your feet, so we thought, yes, Dr. Gutwami, at least we'll have some assistance.
I'm always eager to speak in your court, my lords.
With video.
Mr. Gupta, are you appearing in this matter by any chance?
Well, I am mentioning another urgent matter to be taken today. I'll do this.
Wait a minute.
It appears, my lord,
Thought she is wrongly.
it appears there are 500 people, my lord, on the video, where the video is off. I don't know whether it's for this case.
There is a mentioning education matter. I presume that is not related to this, sir. You are mentioning some other matter?
Yeah, some other matters. I'm mentioning is an education matter for.
I'll come back to you in a moment. I just wanted to verify whether you are in this mentioning matter, which is being presently mentioned before us. We'll come back to you. Don't worry. Don't get angry. We'll come back to you at a party in person.
Ma Pushpavani is there. Ma Pushpavani. M-A-A.
Can you speak to them on phone?
Yeah. I've told them, so they're coming on.
We can put on the phone, put the speaker on.
He's asked.
See the earlier one.
So the argument is that they have been.
Supposed to do is, obviously you can't let the police, you can't let in the army or the police into an establishment like this. We want to put to you something which we would like your response on. What if we ask the District Legal Service Authority to request the Secretary of the District Legal Service Authority, who's a judicial officer, to visit the premises, talk to these two inmates, and apart from this, if there's any other
She is here.
to submit.
Muting.
Video.
Yes, where are they? Yes, ma'am.
I'm here outside, at Isha Yoga Center. I was just eating something. I'm sorry for joining late. I didn't know about this. This is my Mayu.
Yes, ma'am. What do you have to say? You are aware of the fact that your father had filed a habeas corpus petition.
Yes, we appeared at High Court for the same, and we explained that we are here at Isha Yoga Center by our own will. And we also told the Honorable Judge of the High Court that this harassment from our father's side has been continuing for the past 8 years.
Ma'am, what are your educational qualifications?
I've studied.
What we'll do is this, we'll pass that order now. We are staying the direction of the High Court to the police, because if 500 police, as you say, have entered the ashram without any prima facie, even a prima facie opinion, at the same time, what we will do is that we also exercise a sort of a parents' patronage jurisdiction.
Certainly.
Right? So we'll ask the Secretary of the District Legal Services Authority to, it's a very different thing from, police, suddenly 500 police. It's an officer who is responsible to us, judicial officer who knows how to conduct these proceedings, trained in that. We'll ask the Secretary of the District Legal Services Authority to visit the ashram, talk to these two women, because talk to both of them, interact with the other women inmates of the ashram and submit a report to us. I think that will be, we'll have stuff.
That's in fact exactly what took place last time. Page 24 bottom. Chairman of the Legal Services Authority, who was a district judge.
They make a submission.
No.
I'm not hesitant in somebody visiting, etc. It may set some bad portents. Somewhere something happens, the order of the court is cited, now said district judge send this, send that. Creates a problem. My submission is this. The Lordship may stay the order. These ladies are here, she's here. Again, you can tell your Lordship. She said that 8 years ago also. Lordship, she can come to court, she can come to Supreme Court. If your Lordship desires, I can call her to court.
14th otherwise, 14th October.
Or
they're both there, I think. Both of them are.
there is the second person.
She's next to her. I just saw her putting it.
Mr. Rohati, since this is a habeas corpus petition, we'd like her to come on screen with us in chambers, because normally we would have heard her in chambers if it was in a physical mode. So we'll retire for 5 minutes to our chambers. We'd like to hear both the inmates.
Both the women on screen.
Chambers on screen.
Certainly, certainly.
We'll come back in 5 minutes. And now the only thing is, Jackie,
Thank you.
Manoj, confirm that the sister is there.
Is your sister with you also at this point of time?
She's here. She'll be here in 5 minutes.
All right. So what we will do is we would like to interact with you in chambers, ma'am, since it's a habeas corpus petition. And
Yes.
Our registrar information technology, Mr. Hargurvinder Singh Jaggi, will just take your link and provide, he'll ensure that we are on the same link in our chambers. So just come and speak to us in 5 minutes. If you are here physically, we would have asked you to come to the chamber physically. Since we are on a virtual platform, we'll just do that in 5 minutes and we'll come back.
Yes, sir. Thank you, sir. Yes, sure. Thank you.
Please come back. You can always be here. Solicitor, we'd like your assistance.
Very good.
Your Lordship will continue mentioning, madam, after hearings.
We'll do the other mentioning, we'll just finish because they don't have to wait. Yes, yes.
There's a, Lordship, there's a.
Just one second. Puneet?
Urgent mentioning, my lords, this concerns an order by the Police Commissioner of Delhi dated 30th September. So this order was passed where the Commissioner prohibits a gathering of 5 or more persons. Now this impacts the city right now because the Navratra season is on, Dashera is on, Ram Leela cannot take place, my lords. Durga Puja festivities cannot. My lords, the problem is, no, my lord, that matter is a separate matter. Here, devotees come from UP, they come from Haryana. My lords, this impacts multiple states. My lords.
Solicitor General says that the order by the Commissioner of Police has been withdrawn.
No, my lords, my instructions are, it's still in place, it operates till the 5th.
The police is the subject of the union.
Go on the record.
Today matters are listed before Delhi High Court.
Because if we say that on the record, then because my instructions were, it continues to the 5th of October.
Because police is a central subject.
Of course, my lords, we are very aware of this.
May I mention a death sentence?
May I mention, my lord, some update, my lord.
Mr. Gupta, just 1 second. Just 1 second, Mr. Gupta.
There is an order of demolition of a petrol pump. On 27/9, we lost in the High Court on 23rd. Now they are going to demolish it.
Was passed in the
The demolition matters, my lords, have already always accommodated. So if it can be taken up.
Yeah, list before a bench presided over by Honorable Mr. Justice Suryakant.
Lordships.
Not I mentioned the arbitration matter section 50 appeal where liberty was granted us to file SLP. You filed the SLP, it may come on 14th October, my lords.
Okay. Puneet, that other matter which has to be tagged with the arbitration matter which we have kept on the 14th. Please go.
Lordship.
The second impugned document.
Lordship, I have mentioned emergency parole for a death sentence prisoner. Your Lordship have already allowed listing for tomorrow. The issue is that the last rites as per Muslim rituals is on the 40th day, which comes during the holidays.
It's coming up tomorrow.
Lordship, the issue is that tomorrow would be the only opportunity for the court, and then after that it would become. I'm only seeking that the state of UP be given.
Serve the list before a bench presided over by Honorable Mr. Justice Sandeep. Huh? It's already listed. It's already listed.
Lordship, the issue is Lordship, may I explain? The issue is that it would come up for the first time tomorrow, and that would be the last working day. The state of UP may not be able to verify that the relative is.
The Registrar Judicial will just tell you before which bench I have assigned it for tomorrow. You can then mention before that bench that give me liberty, or you can serve.
Lordship, just permit me to serve the state of UP and direct them
serve
to
it on,
present.
serve it on Ms. Garima Prasad.
Obliged.
Lords, may I mention a matter for urgent listing for tomorrow, Lords? It essentially deals with the eviction and demolition of a hospital running in Agra, Lords. We've lost in the suit before the trial court.
When was the impugned order passed?
Lords, the impugned order was passed by the first appellate court, my lords, rejecting my additional evidence, and which was challenged before the High Court. That the High Court has also dismissed.
Evidence.
Lords,
when was the impugned order passed?
Lords, it was passed on 7th of August. Lords, we filed the petition. It was, Lords, it was also.
Lords, permission to mention, Lord, that woman. Lords, may I say?
Yes, ma'am.
With the Lord's permission, Lord, disposition. Lords, may I mention, Lord, there is a shoot at. He's entitled to protection under the MSMED Act.
When was the impugned order passed?
Only on October 1st, my lord. This is the earliest opportunity.
Already, we'll come back. You mentioned. Yes.
Lord, that woman, my lord, short service commission officer, Lord, Lordships had issued contempt, my lord. It's been supposed to be listed about 4 months, my lord. Any date after the break, my lord.
No,
on 14th, my lord.
That can be done on the email.
On the 14th, no, my lord.
Minors are about to leave.
Lords,
no,
there's a shoot at site.
Contempt matter. It can certainly be.
Lord, we have made that request about 10 times, my lord, to the registry, my lord.
Then what do I do? We have 34 judges handling 65,000 cases.
I vote on.
After notice.
Yes, my lord.
Fresh cases we give priority.
14th if it's possible.
It depends what kind.
14th, my lord.
My lord, there is a shoot at site order, my lord. Shoot at site order, I am mentioning, my lords.
Ms. Rocky, we had an exchange and an interaction with the two monks, who are sisters, and they have indicated two things to us, that they are staying there since they are now 27 and 24, right? No, they were 24 and 27 when they went to Ashram in 2009 or so.
Correct.
And they are staying there voluntarily of their own accord, and they don't want to leave the ashram. There is no compulsion on them. That's one thing which they said. Second, they said that the police were there for 2 days, but they left last night. The entire the police team has left the ashram.
There is no police.
There is no police,
Those
right?
told some are still there, but I may be wrong. They may be right.
And so.
But your lordship may be pleased to stay this order, Lord. This order creates, yes.
The petition, diary number 45881 of 2024, the specially petition under Article 136 of the Constitution arises from an order dated 30 September 2024, passed by a division bench of the High Court of Judicature at Madras. We have apparently, do you have any instruction? The police seem to have left the premises.
I just say this, Lord, if a matter is to be mentioned, your lordship is going to take it up, Lord, based on the mentioning, at least the state should be informed. I've just got to know from the news, my ear was not.
No, our order is, our petition is against the High Court's order. The High Court, the state is acting and the High Court.
I'm not aware what they stated. What they
but do you have any instructions on what
I don't have the I don't have the petition. If I have the petition, I'll be able.
All right, we'll list it on the reopening, because we have to pass some interim order right now.
Just a minute, Lord. I'll just see, Lord. If there is nothing against the state, Lord, then that's not the issue.
It's only directed against the High Court's order.
Just
we have nothing against the state.
Moment, Lord.
Please.
Moment. Lord, because the way it has been reported, on which my colleagues came running, they've collared this.
Mr. Luthra, just listen to the order.
Yes, of course, Lord. I'm sorry. I'm sorry to interrupt, Lord, but it's my duty to point out.
A habeas corpus petition was filed under Article 226 of the Constitution by the first respondent seeking the production of his daughters, Geeta Kamaraj, and Lata Kamaraj, who he alleged were who he alleged were held captive inside the premises of Isha Foundation at Coimbatore. Full stop. The division bench, by its order dated 30 September 2024, noted that it had, into invert commas, examined both the detainees and the petitioner. Full stop. The order of the High Court does not specifically refer to what transpired during the course of the interaction between the High Court, between the bench and the and Ms. Geeta Kamaraj and Ms. Lata Kamaraj, and the corpus. Full stop. In order to obviate, the petition was mentioned for urgent orders. Before that, you say, the High Court, after noting the submissions of counsel for the petitioner, to the effect that there were several other persons who were staying at the ashram of Isha Yoga Foundation of Isha Foundation in Coimbatore out of compulsion issued a general direction ordering that, into invert commas, with reference to the said allegations, Coimbatore Rural Police having jurisdiction shall conduct an inquiry and file a status report before this court. Into invert commas complete. Stop. The petition was mentioned for urgent listing by Mr. Mukul Rohatgi, Learned Senior Counsel, on the ground that, in pursuance of the order of the High Court, about 500 officers of the Coimbatore Rural Police entered the premises. It has been submitted that the interaction with the division bench of the High Court took place in the open court, in the course of which both the individuals concerned stated that they were staying at the ashram voluntarily and without any coercion. Next. During the course of the hearing, we were of the view that it would be appropriate for this court to interact with both the individuals concerned, which we have done at the chamber hearing online. Stop. During the course of the hearing, during the course of the interaction, both the individuals stated that they joined the ashram at the age of 24 and 27 years respectively. Stop. The text of the order of the High Court indicates that they are presently 42 and 39 years old. Stop. We have had the benefit of interacting with both the individuals who have stated that they are residing at the ashram voluntarily and without any coercion. Stop. Moreover, they stated that they are free to travel outside the ashram, which they have done from time to time. Stop. Moreover, they have stated that their parents have also visited the ashram to meet them periodically. In fact, one of the two individuals stated that she has participated in a marathon of extending to about 10 kilometers in Hyderabad. Stop. As regards the presence of police, in pursuance of the order of the High Court, it has been stated by the two individuals that the police have left the premises after conducting, they have left the premises last night, though they were there for 2 days in pursuance of the order of the High Court. Full stop. The submission which has been urged on behalf of the petitioners essentially is that while entertaining that a similar petition was filed by the mother of the two individuals about 8 years ago.
In which the father also appeared.
The same statement as was made before the High Court on this occasion was made by the two individuals. Hence, it has been submitted that recourse to us. Hence, it has been submitted that the filing of a second habeas corpus petition ought not to have been entertained on these facts, particularly having regard to the age, maturity, and volition of the two individuals. Next. At this stage, we are of the view that the ends of justice would require the following order. Bracket 1. HCP number 2487 of 2024 shall stand transferred from the file of the High Court of Judicature at Madras to this court. We permit the first respondent, who is the original petitioner before the court, to appear appear on the virtual platform, to appear through the video conferencing platform if he wishes to interact with the court in person or through counsel, either on the same platform or physically as he may desire. Semicolon. Bracket 2. The report, which was the status report, which was directed by the High Court to be filed by the police, shall be submitted before this court. Semicolon. Bracket 3. Further proceedings in person. Full stop. The police shall not take any further action in pursuance of the directions issued in paragraph 4 of the impugned order dated 30 September 2024, 7 except for the submission of the status report to this court.
Only one correction. I made a mistake. I said 500. The petition says only 150 police. Lordship may correct.
But there's one thing.
I was told only 500, but the petition records 150 police officers visit.
But Mr. Rothki is right. But may I just add one more thing? Not just one thing I need to add.
So, we are, besides Mr. First up, Mr. Siddharth Luthra, Learned Senior Counsel, has appeared in these proceedings on behalf of the government of respondent.
But one statement I want to make, but just to clarify, but the petition at page R says 150 people, and what makes unfortunately a statement that police forced the persons to give handwritten letters as per the asking. What I want to point out factually was one, that the police was accompanied by the district child protection officer, the district child welfare committee, the district social welfare officer, 2 psychiatrists, and the JD health and the drugs inspector. So, Lord, I'll give the list of all these officials. So they were all part of the team, Lord. It can't be, Lord, because they're trying to.
I'm saying nobody's gone.
No,
how can anybody go like this?
I'm sorry, I think Mr. Rothki is absolutely wrong.
Just say this, Mr. Siddharth Luthra, Learned Senior Counsel.
Not the High Court gives an order, do I not?
I'm not blaming you. I'm saying High Court should not have made an order.
States that the police team which conducted the inquiry in pursuance of the impugned order of the High Court was accompanied by bracket 1. Just put it.
I'll put it down in writing, Lord.
So we'll list this now on the reopening after the mini break.
That's right.
When would your Lordship?
That will be on the 14th. Sure, that will be of 14th.
Your Lordship
request. The report will be directed to be the status report may now be submitted by the Standing Council for the State of Tamil Nadu to this court.
Yes, may I suggest your Lordship may call it on 18th, Lord. The 14th will be the reopening day, some filings, etc.
18th
may be better.
18th is fine.
Only one request, my Lord. Lord, only one request. I am for Union of India. Lord, some observations orally were made by the bench, which, my Lord, could have been avoided if your Lordships can consider stay of further proceedings before the High Court. My Lord has seized off the
High Court. You have transferred the proceedings to our court.
Then there is no difference.
That's fine.
But the union is a party here.
No, I'm going to add the union because
Yes, sir, we are concerned.
Mehta is always welcome. Mr. Mehta is always welcome, Lord. I just have one thing to say, Lord, and it's always a privilege to have him around. Now, not just one thing I must point out, but your Lordship is doing it for the 18th?
18th. My Lord, I have filed an impeachment for the union. Your Lordship may add them, my Lord, because this has
fair enough. I didn't have this, sir.
Far-reaching effect, my Lord.
My learned friend, I was aware, I was made aware. Now, Lord, I have just one thing to say, Lord. We would not have troubled your Lordship and come running, except that it seems there were some statements made by your Lordship which seem to have misquoted by the press, as if there was something came, as if your Lordship had observed in the police. So therefore, Lord, we came running. Otherwise, we would not have.
We were listening to what Mr. Rothki was arguing.
No, this is a problem of the medium. The court did not say a word. I did not say a word about the.
We were just executing the order.
The High Court. That's all.
Grateful. I didn't realize.
Grateful. Very good.
Thank you. We've got the copy of the application. Grateful.
And the only thing which we indicated was we'd like to hear them in the privacy of the chamber because the habeas corpus petition.
But that's appropriate. But it's always better. There are some things better done in chambers than in court.
Grateful.
Much good. Most grateful.
Okay.
Now, Jet Airways, we will have to keep it on the reopening because I have to.
Give your parents.
I can't finish in an hour.
So, Rothki, you have never said that. You always take less time than what you tell us. So we'll keep it on the reopening, right? And the same board, since we are now rising, my learned brothers have a separate board which will be taken up. This board will be repeated on the 15th.
So not everybody knew after that the note came, not everybody could understand what it is. So there was a separate note, Lord, this will happen, so we were all aware of it.
All right. So my learned brothers will continue with the board.
So very good.
We have mentioned.
order
Happy Dasara, so that we will not come after this.
All members of the bar are very happy Dashera.
All of
my lords, there is a shoot at sight order, my lord.
Yes, my lordship, your lordship.
If everybody is going to scream at the same time, we'll just rise. If there's going to be some order, Mr. Gupta has been waiting for a while.
Yes, my lord, there is a shoot at sight order of leopards in Rajasthan, Udaipur, my lords. And my lords, there are forest guards, there are shooters called from Hyderabad, my lords. They are on the field. I am requesting for today. It is against the guidelines of the National Tiger Conservation Authority, my lords. And we got the order yesterday at 10 o'clock through social media. There are copies, my lords, I'll pass on.
Before the bench presided over by Justice Gawai.
Today, my lords. Today, my lords.
All right. Then education matter, sir.
Yes, my lord, it's education matter. It's admission matter in MBBS Chandigarh College, which is pending since 2019. And
that will come up on the reopening. Yes.
I'm mentioning.
Mr. If you want to mention something? Mr. Solicitor, you are.
Yes, my lord, I wanted to wish happy Dashera to all three of your lordships, but with a request to enjoy the Dashera vacation, my lord, and not to work.
That's never a reality. It's all of us are going to be preparing judgments which are pending.
I know, my lord, I know. That's
with my lord's permission, I'm mentioning a fresh matter. My lord,
One second. Just cool your heels a little bit. Just because you are doesn't give you an authority to raise your voice. Right?
Because I joined the learned Solicitor General and wishing happy Dashera.
Anybody here who wants to mention
I'm
anything?
only asking, today's board is on the 15th now.
Yes, that's
great.
Mention item 7, which is the admission matter of a disabled candidate. Lord, the counselling is going on. So if your lordship is kind enough to list it at 2 p.m. at any other.
It will be listed in the combination before Justice Pardial and Justice Manoj Mishra right away. No difficulty.
Don't break the line. Don't break the line. Now continue process.
Scheduled to be, it's for today, my lord.
Sorry?
The petitioner sought to be dispossessed today, my lord. He is an MSME entrepreneur.
When was the impugned order passed?
October 1st, my lord. Your lordship, kindly take it on board today.
Who's dispossessing you?
My lord, these are surfacing proceedings. This is a MSME petitioner. He is entitled to protection under the MSMED Act, my lord.
This impugned order was passed by whom?
The High Court of Bombay, my lord. On October 1st.
Will come up before the regular.
My lord, this is a 74-year-old person, my lord.
We'll reinstate you. And why do you go to the High Court of Bombay? You should have gone to the DRAT. So
Lord, he's entitled to protection under the MSMED Act, my lord. The DRT does not have jurisdiction to.
But we'll not pass any order without your circulating. You could have circulated the matter even yesterday. Yes.
Yes, my lords. Apologies for the.
Yes, come on.
Previously, my lords, I'm running my querying operations and mining operations 2015. Now, suddenly, a month back, it has been suspended without any.
Was it the same matter which was mentioned yesterday?
No, my lords. We are mentioning for the first time. 2015, I'm running without any difficulty, no issues. In fact, there are two.
So for 1 month, you're not running.
My lords, and the impugned order by the High Court simply said issues notice. I press for a stay.
On the reopening, yes.
My lord, as advised by your lordship, I have deleted the name and I request you to list my matter tomorrow, sir.
Now it will come up. Not tomorrow, it will come up on the reopening. Yes?
I was mentioning that additional evidence matter, my lords, before your lordship rose up, my lord. Because my difficulty is that, my lords, the day after tomorrow, the first appellate court is concluding the matter, my lords. So I am requesting your lordship to have it tomorrow, my lord.
It's a ground which you can take up while challenging the order. Yes.
SLP.
You made it clear, yes.
That item 8 is that regular bail where I'm in custody for 14 months. My lord had it after 2 days. 2 days back, my lord had listed today. Is that ED matter, my lord? In case your lordship may have it today.
It come up immediately at the bottom of the board of Justice Pardiwala and Justice Mishra.
I'm so grateful.
My lords have said that it will be Jet Airways, Godavarman and then marital rape, my lords. But my lords, for about a long time, we keep getting displaced, my lords. So we'd be extremely grateful if on reopening.
Same order will be maintained. Jet Airways is partner, then comes the Delhi Ridge matter and then this matter.
But if we could really be heard on that date, we'd be extremely grateful.
That I'm not sure because it depends on all of you. We are here to hear every matter. But sometimes getting lawyers to argue is more difficult than deciding a case.
We've been there on every occasion. Happy holidays, my
That judges pension matter, my lords.
Yes, Nina.
That judges pension matter, my lord, your lordship said take it today. First matter, your lordship said.
On the reopening.
Before the two.
No, that will come up on the reopening. Because that requires a 3-judge bench.
Could I mention item number 13, my lord? 30, which is listed before your lordships today. It is that matter in regards to security and 1700 crores award in favor of the NHAI, my lord.
That will come up on the reopening. Right? There, 15th. Yes, 15th the board will come up.
Lords, may I at least request for reopening Lords 14 if possible?
Lords, may I mention a matter listed on Monday, 30th of September. Lords made certain observations which were dictated. Lords, these were eventually what missed out from the final order. So, my lords,
final order is the final order.
Lords,
observations in court during the course of the hearing are matters which we will decide.
Those observations are still in the Mr. Courtmaster's book. So,
how do you have access to the Courtmaster's book, I say?
Lords, we cross-checked. Before mentioning, Lords, we cross-checked.
With which Courtmaster?
Lords.
Did you tell him what was dictated in the court? Did you have this conversation with him? He said something to the contrary. How dare you ask the Courtmaster what was dictated in the court?
I'm sorry.
Tomorrow you will come and sit in my house and ask my secretary what I am dictating in the chamber.
I'm sorry.
The order which is there is the last order. Show me what was dictated. What is it that you want? Lawyers have lost all sense of decency or what? The final order is what is dictated in the court. What is signed by us. So what was there? What do you want? We have appointed an arbitrator.
Milords left the contention open for the existence of the arbitrator, the agreement and the limitation question for the arbitrator to decide.
But that is always so. That is always so. All contentions are open. In a section 11 matter, you only said you are appointing an arbitrator. Yeah, we have only appointed an arbitrator. You can always move an application under section 16. And don't try this kind of funny tricks with me again. Huh? I don't have a very long time around on the bench. But until the last day I'm in charge. Don't try this. Going to my secretary, going to the steno. Aapne usse bataya kya kiya? And then you tell, because why would he tell me? Unless you know shorthand. Up under